Thank you, Presiding Officer. It's not possible in the time available to cover all the aspects of this really important report. In the short time that I have, I'll speak to two areas of concern that I would welcome further discussion with the Minister in order to explore possible resolution or amendment at stage 2. Those are legal representation and the treatment of child victims of crime. In terms of legal representation, it's of grave concern to me that a young person could accept offence grounds without understanding the full implications of that decision. As Katie Nisbet of Child Clan Law explained in her evidence, offence grounds are libelled in the same way as a criminal charge would be, including reference to the crime and the behaviour that supports that the crime has been committed. Where those grounds are agreed by the child, without a hearing on evidence and with no automatic right to legal advice, they can be disclosed in PVG checks years later. I do acknowledge the points made in the Government's response to the committee report that an offence dealt with through the hearing system is spent immediately. However, it is the case that for offences such as serious sexual violence, theft and fraud, these remain visible on PVG checks. It's not difficult to see the impact these would have on future employment opportunities in later life. The child will only be referred to a solicitor if they refuse to agree the grounds or don't appear to understand the grounds, in which case the matter is referred to the Sheriff Court for what's known as a proof hearing. Although advice by way of representation can be applied for, it's considered on the basis of a means and merit assessment. In other words, it's not granted as a matter of right, nor is there any duty on part of the children's reporter to ensure a child knows about this option to obtain legal advice. The seriousness of the consequences of agreeing offence grounds, that it will be treated as a criminal conviction in certain disclosure contexts, is not always adequately explained. Neither is the potential impact of the disclosure of the criminal offence. As such, I support Child Clan Law's calls for automatic legal representation for children when being presented with offence grounds, and feel this should be addressed on the face of the bill. Our committee report recognised the challenge of balancing rights of those offending against those of the victims harmed by that offending behaviour. This is never starker than when both parties are children. MSPs will recognise from their own casework situations where that balance has been off, has not felt just, and the child harmed has been further traumatised by the actions of our care and justice system, a system that was intending to do their best for the child who had caused the harm. Giving evidence for Victim Support Scotland, Kate Wallace stated that the balance of rights in the bill as currently drafted isn't correct, with the focus on the child who is harmed and not as much on the child who has been harmed. She went on to explain that with regard to information sharing, if you're offended against by an adult, you can opt into a victim notification scheme in order to get information if someone has escaped or absconded from prison. You're also entitled to know when they're released. However, if, for example, you've been subjected to a serious sexual assault by a child or a young person who ends up in secure care and goes through that route, at the moment you will not be informed about when they leave that secure establishment. Presiding Officer, I fully understand the challenges around information sharing, but feel it's simply not good enough that in such circumstances victims cannot plan effectively for their own safety. To build on Scotland's progressive approach to children's rights, in line with the UNCRC, we must not shy away from acknowledging and addressing the potential conflict of rights, then carefully, openly, working our way through the issues to balance them. It can and must be done. I believe this is essential, fundamentally, for obvious reasons of fairness, but also, as importantly, because by getting that balance right, we'll ensure that the public have confidence in these really important reforms to improve our justice system for children and young people.
Thank you. I now call Rose McCall to be followed by